Please come forward. You've got House Bill 2066, custodial interrogation of a child.
Mr. Chairman, members of the committee, I'm here to present House Bill 2066. I believe the clerk has a substitute prepared.
Yes, Mr. Chairman, there is a substitute. It should be on your desks. This is now posted on LIS. What this substitute does is in Section C, it adds an initial sentence, 2 sentences before what it was originally a statement of leniency. Kind of makes the bill do a little different things than it was originally introduced. I'll let the delegate speak to that, but that's really essentially a different beginning to opening of paragraph C.
All right, is there a motion to adopt the substitute?
Second.
All right, all those in favor say aye. Any opposed? All right, the substitute is adopted. If you can speak to it, please.
Yes, I'd like to speak. So the bill, as originally written, would have created a rebuttal presumption that any statement by a child after a promise of leniency made by the law enforcement to a child prior to or during an interrogation was not made knowingly or involuntary. The substitute adds to that any knowingly false statement regarding evidence that is designed to elicit a confession. A confession. So it additionally creates a process to ensure that a hearing evaluation that the facts and the circumstances of the juvenile confession prior to trial.
Okay, questions for the patron. Delegate Williams.
Speak to the bill. I'm sorry. I was speaking to the substitute.
Oh, you're not done?
No, I just was giving you guys a chance to digest that substitute.
Oh, my apologies.
All right, so I'll go ahead and speak to the bill, Mr. Chairman, if that's okay.
Oh, yes, of course.
Okay, Mr. Chairman. Okay, so the problem this legislation attempts to solve is the lack of adequate judicial review and incriminating statements by minors. In discussing the legislation with stakeholders at this point was often made that judges already automatically provide these review of confessions made by minors. Statements to the effect of this is already happening has been made to me in numerous conversations. However, and I have, I have an attorney here in my district to speak to this, that this review, in fact, is not automatic. It depends on both the police, prosecutors, and the defense attorneys having the time and presence of mind to adequately review these statements for the defense of the motions made for them to be executed. So many of you, perhaps, maybe all of you, are aware that our legal and law enforcement system is currently in a state of crisis. Specifically in my district, crime is on the rise where police, prosecutors, and public defenders are critically understaffed and I do not believe in the situation will provide the short or even medium term resolution with this. So what this legislation attempts to do is to accomplish this creation of a judicial safety net when dealing with incriminating statements by minors, requiring the prosecution to provide 10 days notice prior to the trial of their intent to admit incriminating statements made in a custodial interrogation, and requiring that the judge ensures that a hearing exploring the facts and circumstances surrounding the statements are explored. And again, I have with me a witness, an attorney from my district specializing in the representation of juveniles to explain exactly why exercising this legislation is necessary for the kinds of issues that are currently being faced by juveniles under the current law. Mr. Chair.
Okay, thank you. Any questions for the patron? Delegate Williams.
Yes, question for the patron, Mr. Chair. Delegate Glass. Why do you think crime is out of control in your district?
Mr. Chair. Sorry, Mr. Chair. I would say I don't believe crime is out of control in my district. I believe that we, like many cities across the country, are dealing with the rise in crime through multiple factors.
Okay. Any further questions?
Mr. Chair.
Delegate Williams.
Would one of those factors be the defunding of police and other law enforcement officers?
Mr. Chair, I would say that we are in a state where there is a little self-defunding that has been done and that there are resources and other issues that we need to sort of surround to have a comprehensive walk towards really imagining what it means to do law enforcement in the 21st century, Mr. Chair.
Okay. Any other questions? No? You? No? Okay. All right. Well, let's hear from your witnesses now. Okay. Anyone who wishes to speak in favor of the bill, please come forward.
Good morning, Mr. Chair and Subcommittee. Thank you for hearing from me. My name is Catherine Curran. I'm the managing partner of Morris, Crawford & Curran. We have offices in Norfolk and Chesapeake. I'm a citizen of Virginia Beach, and I've also taught juvenile law as an adjunct professor at Regent University recently. The reason why this bill is really important is because children are different. We're trying to protect children and make sure that their developmental status is being adequately addressed. So for a long time in our legal system, in a lot of ways, we treated children and adults the same. That's why we used to let them work in factories and we didn't make them go to school. But obviously, as we've learned more and more about children's development and what's good for them, we have tried to make sure that we always act in their best interest, and that's the purpose of the juvenile justice system. So we now know through the National Registry of Exonerations that of all of the exonerations that have occurred, so we know that these people are actually innocent. They did not commit these crimes. That 12% of the total cases that they have include a false confession. 12%. If it is a juvenile case, that number is 34%. So that shows you that this is a developmental issue. This is an issue that is much, much worse for children than it is for adults. And if you break it down by age, it is even more severe. Children under 14 confessed in 78% of the cases where they have found to be actually innocent. 78% for 13 and under. For 14 and 15-year-olds, the number is still 54. Over half of those children who have been released because they did not commit the crime said that they did it at the time. And it makes sense because we all know teenagers. Teenagers are impulsive, they make bad decisions, they think in terms of very short-term goals. And so when you are a child who is in the presence of a law enforcement agent, you are inclined to do whatever you need to do to get out of that situation. Are you telling me that if I say I did this, I might be able to go home? Okay, I did it. That is something that happens. And I don't know how many of you may be familiar with the popular series that came out, When They See Us, which is about the Central Park Five. 4 of those 5 teenagers confessed to committing the charges that they were charged with in custodial interrogation. I'm not saying that every custodial interrogation looks like that and that children are being beaten up. But what really is happening now is that we are not treating them differently in terms of the way the law is written. So the way as law is written is that there is no difference between children and adults in terms of how we decide if their statement was knowingly, intentionally, and voluntarily made. And that's the constitutional standard that we have to meet. We don't let people's statements be used against them unless they made them voluntarily. So we know that children process this information differently, and we've started carving out other places in our law where we make exceptions for that developmental difference, and this is about making sure that we're not sending innocent children away. Because the damage that you do to a child by incarcerating them, separating them from their family, is something that you cannot undo. This is the period of time when children's brains are developing the most. It's when they need the support of their family and they need to be with them. And we need to make sure that we are not being short-sighted in the way that we handle these situations, and that every child, if they have confessed or made statements about a crime that would tend to implicate them, that those statements have some credibility to them and that they are not being made after that child may have heard someone say that they might be able to go home or that they could talk to their mom again after just a few more questions, because children are just extremely susceptible to being led by police officers. And the other thing I want to talk about is bringing our values in line with our law, because we want children to be able to trust police officers. We want children to trust that those police officers are going to keep them safe and that this is someone that they can be honest with. And we can't, I don't think, then have a law that says that our police officers can lie to our children.
Thank you. Will you stand for a question if anyone has a question?
Absolutely.
All right. Anybody have a question on the committee? So you're in favor then for basically changing a presumption that a statement is knowingly and voluntarily made to a presumption that it's not for any child.
That's not what this law does. So every statement that's offered is evidence that can be received by the court. What this requires is, well, currently the state of the law is that if the Commonwealth offered a statement, then in order to suppress that statement or have the court take a closer look at it to make a determination if it was voluntary, the defense attorney would have to make a motion to suppress that statement and say it was involuntarily made. This would bring extra attention to this particular issue because we know that statistically it has borne out to be a problem and create situations where innocent children have irreparably been damaged. So we want to make sure that this is done correctly. And the way to do that is to make it an automatic process as opposed to requiring it to be brought to the attention of the court.
What if the child confessed to an element of a criminal offense, but not to the entirety of a criminal offense? Would that also require a filing by the prosecution 10 days prior to trial for a judge to determine whether it was reasonable or knowingly and voluntarily made before you could present that evidence in court?
I believe that this would.
Okay, thank you.
Thank you.
All right.
Mr. Chairman, question?
Delegate Watts.
Yes, a question of the witness. Thank you. I draw your attention to the substitute on line 12. There is in this review by the court prior to the trial, it says that should the officer knowingly provide false information regarding evidence in the case in an attempt to elicit a confession, so that the burden is going to be on the defense to prove that it was done in an attempt to elicit the confession. Is that correct?
Yes, and I think that people who deal in juvenile law regularly, like our juvenile court judges, would be prepared to understand that. To give a little background, there is a process that many police departments use for training called the READ technique, which is a technique that is used to train police officers to help them get information from suspects. And so the READ technique would suggest things like putting a fact into the person's mind that might not be true, but would make them think that you did in fact know that. And so if it were true, even though you don't know that it's true, it would convince them that you did know that, and therefore they would go ahead and confess to what they had done. The problem is that those sorts of tricks, so, we got your DNA, so you might as well say you did it. An officer is allowed to lie to an adult. At this point, an officer is also allowed to use that same technique on a child. And so they can say, we got your DNA there, so you might as well go ahead and tell us you did it. And for someone whose DNA is actually there, that might work. And they may say, oh, well, there's no point in me hiding it because my DNA is there. But for a child, maybe who hasn't done it, they don't have the capacity or the ability to reason through, I know I didn't do this, so there's no way my DNA is there. They think, oh, no, something really bad is about to happen to me, and so I should do whatever this officer tells me to do, because that's the panicked brain of a teenager. They go into fight or flight and will admit to things that they haven't done.
Mr. Chairman, I thank the witness for an example of intent. Thank you.
Thank you.
Is there someone else? Okay.
Mr. Chairman, Subcommittee, my name is Tiffany Traxler Crawford. I am a proud resident of Norfolk, Virginia. I do not reside in Delegate Glass's district, but I do live in Norfolk. I am also a named partner at Morris, Crawford & Curran. Ms. Curran is my law partner at the office. I also have served as a criminal defense attorney for juveniles for nearly 14 years. I have also taught juvenile law at Regent University School of Law. I come to you today in support of this bill, not only based on my professional capacity, but also as the mother of a teenager and the wife of a high school teacher. I have lots of experience with teenagers in professional capacity and personal capacity, and I do believe that this bill is needed. As an anecdotal example, I bring you Anne of Green Gables. I'm not sure how many of you read Anne of Green Gables as a child. However, there's an interesting conversation that happens in chapter 14 of Anne of Green Gables, where Anne is accused of stealing a brooch. She's told she cannot leave her room and go to a church picnic until she confesses to stealing the brooch. So what does Anne do? Anne confesses. However, it's later found out that Anne did not steal the brooch. And when she is asked, she says, "Why, you said you'd keep me here until I confessed," returned Anne wearily. "And so I decided to confess because I was bound to get to the picnic. I thought out a confession last night after I went to bed and made it as interesting as I could. And I said it over and over so that I wouldn't forget it." Anne of Green Gables was written in 1908. And Ellen Montgomery realized at that point that children will sometimes confess to things that they did not do to get out of trouble. Therefore, this bill is needed for that reason. I've sat today and listened to numerous bills that came before this committee saying that we need to do special things in the law because children are different and they deserve to be protected. Ladies and gentlemen of the subcommittee, I present to you that children are different and deserve to be protected even when they are defendants or accused in a crime, and I ask you to pass this bill through.
All right, thank you very much.
Good morning, Mr. Chair, members of the committee. I'm Valerie Slater. I am a practicing attorney defending young folks. I'm also the executive director of Rise for Youth, Reinvest in Supportive Environments for Youth. And in my work with young people, so often I have heard young folks agree to things, say they've done things that they have not done, and it hasn't even been in the legal capacity. And so imagining that young folks are in the custodial interrogation in front of an officer and the things that they will say to get out of that position, we have got to be sure that we are protecting children, protecting them from the overreach, from untruths that may be told to them. For those reasons and for everything that you have heard previously, Rise for Youth and the Virginia State Conference NAACP also support this bill.
Okay, thank you very much. Anyone in the audience who wishes to speak in opposition to the bill?
Good afternoon, Mr. Chairman. Nathan Green, Commonwealth's attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth's Attorneys. Your Honor, I had an opportunity, Mr. Chairman. I had the opportunity to review the substitute. I do appreciate the delegate providing that to me. I also appreciate that she took time to speak with me about VACA's concerns. I think the testimony so far has really somewhat missed the point. Everything that was being asked for to protect children, to make sure that if they make a confession, that there's an opportunity to have that confession reviewed by a judge to make sure that it was truly voluntarily and knowingly made. That exists right now, and this bill wouldn't change anything in that regard. What it would change is it would tell defense attorneys out there, we don't trust you to make the appropriate decisions, so therefore you shall have a suppression hearing in all cases in which a juvenile makes a statement. The additional language about the prosecution will have to provide the juvenile statement at least 10 days before trial, already covered in discovery. We already have to do that. That if a suppression motion was requested by the defense attorney, that the burden was shifted to the Commonwealth to prove that the statement was knowingly and intelligently and with consent made. That's our burden. And if it is a juvenile, the law is different on juveniles than with adults. The judge does take into account the age, whether or not the parents were notified, whether or not there were situations that for this individual, taking into account who they are, how old they are, parents around, was this overly coercive. That already exists in the law. This bill would just make it so that the defense attorney that's assigned to the case has no choice, has no discretion. They shall have a suppression hearing. It doesn't change what will happen during the suppression, just that you have to have it. With regards to the language of...
Before you move on from that, can I just maybe ask you a question about that and maybe challenge you a little bit on that? Because the way I'm reading the first line here is, it's beyond just discovery to the defense. It's that the prosecution shall provide notice to the court of its intent to introduce such confession. So that is beyond it. So that's stopping and saying, before you even move forward in any case, if it involves a statement, and we heard one of the witnesses say that they think that would even apply to an admission of an element, maybe not a full confession, but an element that you would have to prove would require a filing. I don't see how that's workable. Is there a way you see how that's workable for the prosecutors?
I think what it is that I think what it does is, again, turn every juvenile case in which there is a statement into a mandatory give notice to the court that we are going to be having a suppression hearing. And whether it's on behalf of the Commonwealth making that notice, or I guess it would be the Commonwealth putting the court on notice that the court has to have a suppression hearing, regardless of whether the defense attorney wants to or not. The court shall have the suppression hearing, and it would be our job to notify them when that is being triggered. With regards to the definition of a statement of leniency, we now have a both broader and more precise definition of statements of leniency to include comments about contact with such child's parent. I think that goes broad enough to say if you go in and speak with if the officer goes in and speaks with a child and says, "Would you like us to contact your parents?" Well, now that's a statement of leniency. This tries to micromanage both law enforcement in the way they speak with the juvenile, as well as the defense attorneys that are tasked with representing that juvenile's case. And for those two reasons, for that level of micromanagement and I just don't believe that we can by law micromanage those two areas in a way when we already have the protections of the Constitution, the protections for juveniles, that they are treated different than adults, already in place. I think this bill just goes too far, and we would oppose.
Mr. Chair, members of the committee, my name again is Nicole Whitman. I'm a Deputy Attorney General. We also oppose this bill. We would adopt all the arguments made by our friend and colleague at VACA, Mr. Green, and would also state for the court, I'm sorry, again, I did the same thing that he did, would also state for this body that it's incorrect to say that juveniles need to be treated differently, and they are not. They absolutely are. We have a whole juvenile court that treats them differently because there is recognition that juveniles are different. This statute, as it currently stands, without any of the amendments or without the proposition today, acknowledges that juveniles are treated differently. When an adult is arrested, their parents, their spouse, their support system, whoever that may be, is not notified. For juveniles, that does happen. This also, as Mr. Green states, interferes with the judicial process here. You're asking judges now to put themselves in the position of being almost a party to this action, and that's simply not appropriate. A judge has to be impartial. A judge has to not be, show favor towards one side or the other. And when you are giving notice to the court that, hey, this is automatically going to happen, this hearing is going to happen, it takes the discretion away from the Commonwealth Attorney's Office, it takes discretion away from the defense attorney whose job is to launch these type of motions when they see it to be appropriate. Every juvenile is appointed or has the opportunity for the parents to hire an attorney, competent attorneys who are skilled in making these types of decisions. Also, as my colleague stated, the law in the Constitution and a host and a string of long-standing case law stands for the proposition that any such statement that is made that overbears the free will of the declarant, of the defendant, of the accused, is not allowed to be used against them. We don't need to have an additional protection. That protection has been in the law for a long time and continues to this day and is robustly defended. I'd also state that counsel, or that Mr. Green is correct, that the things that talk about the factors that shall be considered and the definition of statement of leniency or release would include the type of charges. So is it lenient to say this is what you've been charged with? According to the statute, it would be. Is it lenient? Should we deem it leniency to say, as he says, we've called your parents, or would you like to talk to your parents? We want police saying that. We want police in the first part of this law to contact the parents and to give the juvenile the opportunity to speak with their parents if they would like to do that. And then, as little 5, Romanet 5, any other promise, condition, or fact. So it would be leniency to discuss any fact of the case with this child. That is simply not appropriate. I'd also suggest to you that, the reality of it is that it is a valid law enforcement tool for law enforcement to discuss the facts of the case with the accused, for law enforcement to do what they can within the bounds of the law that is well established, that is well vetted by multiple courts, by the highest courts, and in courts across this Commonwealth every single day. I've been a prosecutor for 26 years. I couldn't even begin to count how many of these types of motions have been filed and heard. But murderers don't come in and just say, hey, you got me, I did it. There are specific techniques within the law that are used by well-trained law enforcement officers to secure these types of confessions that should be allowed to be used by law enforcement when secured appropriately and properly. So for all of those reasons, we would strongly oppose this bill.
All right, thank you.
Thank you.
Mr. Chair, Elizabeth Hobbs with the Virginia Sheriff's Association. I will not restate all of the things that have been eloquently said before me. I will emphasize that this is yet another bill that's taking the tools away from law enforcement and away from prosecutors, away from the criminal justice system to keep the community safe. Constitutional jurisprudence provides such countless protections over juveniles, not just as a body of people, but as individuals, taking each individual's circumstances, developmental nature, intellectual disability, age, experience, all of those into consideration and determining whether this specific individual's will was overborne by the specific conduct of law enforcement in their interaction. And that is vastly broader and more helpful and already in place and has been for ages to protect individuals, specifically juveniles, from any misconduct in the system. And we oppose.
All right, thank you. Okay, and anyone, well, there's no one online. All right. Okay, Delegate, you have the last word?
Yes, Mr. Chair, thank you. So what I think is not being said was also said very perfectly by the AG's office is that this is contingent upon that child having a good lawyer that their family can hire to be able to say that it needs to happen, that there needs to be a review. We're not taking anything away, but just providing an opportunity to make sure that the judicial review that needs to happen actually happens, regardless as to whether that child is able to have a phenomenal defense attorney to say, hey, we need to take another look at this. I'd also yeah. And I've heard over and over again about the tools needed for law enforcement. I do not disagree that there needs to be tools. I do not disagree that we've come to a place and space and time where the types of tools and things that we use have to be assessed and used differently. But we have to really understand here is that when we look at our juvenile justice system, that there are some broken pieces, and this piece just happens to be one. It gives us opportunity to ensure that we trust in our judges to be a part of it, and that it doesn't matter whether the child has the means, but they have more protections under the law, vice taking away from our law enforcement. Thank you, Mr. Chair.
All right, thank you. Okay, the bill is before the committee.
Move to report, speaking to my motion at the proper time.
All right, there is a motion to report.
Second.
And a second. Now would be the time for...
Mr. Chair, I substitute motion, and I'll do it as a PBI so that Delegate Watts can speak.
I can speak when?
PBI. Okay. I said I'll do a PBI, not a table, so that you can... You sound like you wish to speak. I'm giving...
I do.
Okay.
Yes.
No, I'm making it a PBI. I'm explaining I'm doing it as opposed to motion to table, so there's 2 minutes.
So substitute
for Delegate Watts
motion,
to speak.
superior motion, and there's a second, allows for 2 minutes of debate on each side. So the proponent of the motion...
For the reasons previously stated, I would ask that we PBI the bill. Thank you.
Okay. Delegate Watts.
For the testimony is overreading this bill. All this is dealing with, if you look at the language, is a statement of leniency or providing false information. Those are the only reasons why you would ask for this hearing, not all of the other reasons that are implied that what might be supposed to happen. The other thing that I really want to put on the record, and I hope I say it properly, this is actually a bill for the naive community that trust the law enforcement officer, that the young person trusts, as has been Explain. In my experience in dealing with this kind of legislation, in communities where trust of law enforcement has not been the history of many families, that young person is well schooled in not cooperating. But what you have here is the instance where the young person brought in, oh yes sir, whatever you say sir. And this is where I believe this specificity in the law, as far as, again, these very people are going to tend to be able to afford a lawyer, will have the opportunity for a hearing on two specific elements. The element of whether or not there was a statement of leniency and the element of whether or not there was false information. And I think this is a necessary piece in protecting the juvenile.
Okay, any further debate? All right, I would just say I think this is it's not that my view on this is it's not that children sometimes make impulsive statements or whatnot. I mean, we recognize that happens, but as was mentioned by several of the people who testified, there's existing protections in the law already, and this presents to me it's hard for me to imagine how this would be workable in every case where you would have a burden to provide a notice to the court every time there's an element of the offense that's admitted by a juvenile in this type of setting. And I think it was said micromanaging the system is really, so it seems to go too far in my view, just using up some of the time that's still allotted for our debate. Okay, please record your vote on the board. All right, the motion to pass by indefinitely carries.